All right, welcome back. We have been in court in Georgetown this week, and Georgetown does stuff a little differently because there's many fewer cases down there than there would be in Horry. But what happens in Georgetown is we usually start the week off with the judge, and we will do a trial, generally speaking. Toward the end of that week, everything has to regroup, bring everybody in, say Thursday and Friday, and try to get the pleas done. In Horry, if we were in a term of court, we would have one trial judge and one plea judge in separate courtrooms, and one judge would just hear plea after plea after plea, and the other judge would be seated there with the jury and be trying a case. So we're back in court in Horry next week, but this week was the second week off, and in Georgetown we had a series of cases that came up on the trial roster, and some of them turned into pleas. This is one specifically. Two, I say young men. There was a young man named Javon Har. He's 30 years old, out of Pawleys Island. Too old for this sort of nonsense. But he had been in a running argument with Herman McCrae Jr., who was 27. So you had a 30-year-old and a 27-year-old, and they're making rap videos about each other that nobody's watching. I mean, this is not Snoop Dogg and Dr. Dre making these things. So, you know, just like you may get 5 views, but anyway, it was enough to disrespect the other one. And now the 27-year-old McCrae is dead, and has been dead since February 2020. And Javon Har, who's 30, is going to serve the next 25 years in prison. More typical of, should never happen, but it's more typical of teenagers than people in their late 20s and early 30s. But anyway, Mr. Har will spend the next 25 years in prison. He was called for trial and decided to plead guilty, and he'll serve 85% of that 25 years. So 21 or 22 years before he comes up for parole. In Horry County, even though we are not in court this week, it feels sort of like a break, but all of the guys that have trials coming up for the end of July, August, and September, well, you got to have some time to go out and meet with all of those witnesses. So this week, our investigators have been up and down the roads to different parts of the state, prosecutors meeting and getting ready for other cases. And even today, when I say we're out of court, we're really and truly in court every day, either at bond court or today they're doing preliminary hearings. A preliminary hearing is a step in this process. If you are accused of doing a criminal act, a magistrate would meet with a police officer. The police officer would say, here's why we believe that Jimmy did it. That would be in a warrant. The magistrate would sign the warrant if he agrees with that it's more likely than not that a crime occurred and that I had been the one to commit the crime. They would also sign search warrants, same sort of standard. If you want to lock me up, you may also want to look at my house or my car or in my pockets for other evidence. So the magistrate signs off, and that's a degree of due process. People can't just go out and arrest you without having run it by a judge. That's not always the case, but for the most part, you get an arrest warrant first. After that, you get, as soon as you get arrested, the magistrate will bring you back out. He will tell you of the charges posed against you, and he will give you a couple of court dates to come back and meet with your public defender or your private attorney, and to meet with the prosecutor. He will also give you some paperwork that's labeled for a preliminary hearing. So those take place on Fridays. Today, even though I said we were not in court, there are prosecutors over there running preliminary hearing court. That first judge has already found that it's more likely than not that a crime was committed, and committed by Jimmy. You get, as long as you request it within 10 days of being arrested, you get another hearing that is a preliminary hearing. And what happens there is the police officer that made the arrest, or one of his supervisors, will have to go and swear in and tell why they believe that there's enough evidence to have made the arrest. There's a defense attorney there that tries to cross up the police officer and a judge on the bench to determine whether or not there's probable cause. After that, and most of the time, the judge would have to find that the first judge was wrong in issuing a warrant on probable cause. So most of the time, the preliminary hearing, it's waived to the grand jury. And a grand jury is a group of your peers. They meet in a group of 18. They meet all year long, and 12 of the 18 of those grand jurors would have to agree that it was more likely than not that you have committed a crime. Then the prosecutor gets up with you and says, hey, do you want to plead guilty, or do you want to go to trial? If you were to take a trial right, that is a petit jury, or the jury that you and I are more used to, that we see on TV, that there's 12 jurors that sit there, and their standard is beyond a reasonable doubt. So all of those things that I talked with you about, those are, when you hear that the defendant has more rights than the victim, those are a series of defendant's rights that are necessary by the Constitution, by case law, and by statute. And it's all of those things that I talked with you about is part of the process, and that's what we call due process. The process that's due you before we can take away your freedom. So there's quite a bit to it, and it keeps everybody busy. So even on those times that I would tell you that we're not in court, we really are in court. We're just in a different courtroom. I hope you all have a great week, and we will get together again next week.